right. I think the meeting essentially was focused around the order. When we crafted the order, we provided for a review, which review was intended to see whether we would complete it in 25 days or we need an extension of time. And so essentially that is what the review of the order should be about. However, other matters have been interjected into the process of the review. For all intents and purposes, in principle, we seem to be saying that we would conclude the exercise here on the 13th of June. For all intents and purposes. So I say in principle, that's where we're at. You never know, things could change. But in principle, that's where we're at. The difficulty we're having is that there are those who are trying to prescribe new things into the order, new dates that the order did not previously provide for. So the order said we will have an exercise, a recount, that will take 25 days, and that within a week's time we'll do a review to see the progress. And as I said, that's ongoing, that review. But there are attempts now to specify date of declaration and things like that. Whilst those are things that we have to come to, my own disposition is that the order, and everyone had a chance to read the order, did not provide for that. The order provides for a review of the 25 days. And we really been manipulated to try to now review the order to do things that the order itself did not say we would do as a part of the review. And that's where we're kind of stuck. That's where we're kind of stuck. It's clear that there are people who intend that all we will do is declare a numerical count. And so all that they're doing in this attempt to review the order is to not provide time for the consideration of the observation reports. We are going to have, in addition to 10 tabulations, which have to be brought together into one tabulation, we're going to have 10 observation reports. And those 10 observation reports have got to be discussed. And it takes time. If you see what has been coming up in terms of the volume of information in those reports, it will take time. And what people are attempting to do is to get us to write into the order a conclusion date that will obviously interfere with a thorough and conclusive discussion of what's in the observation reports. And so that is the problem that we presently face with. It's not a new problem. It's obviously a problem that has been there from the inception, where we have collectively made an order that provides for a credible determination of the results. And the credibility has to do with much of what will be in the observation report. And so we cannot arrive at that credibility without a determination of how we treat with what's in the observation report. And what some people are trying to do is to avoid that treatment of what's in the observation report. And so that is where we are stuck. We are to convene again tomorrow at 10:30, if I'm not mistaken, to attempt to craft provisions in relation to those tricky issues. In the main, I think we have said we will probably conclude here on the 13th. But what do we do after that count is concluded? The Chief Elections Officer has to present to us a report which comprises of two aspects: the tabulations of the figures and the observations. We have to get time to consider those reports, or that report. A report coming out of an exercise that would have taken about 41 days. And they're saying to us that a day or 2 or 3 will suffice. My disposition would have been, let us work as quickly as possible on those reports without necessarily saying when we'll conclude. Because when you do that, the quality of work can be affected. But here we are struggling for a date. And it's being suggested that in a process where the Chief Elections Officer brings a report, we discuss that report, and only after that discussion, he's advised to prepare a report under the Representation of the People Act to bring to us for final sign-off. That entire process of the first discussion, his preparation, and the second intervention should take 3 days. In my humble opinion, 3 days are grossly inadequate if we are to give serious consideration to what's in the observation reports. Those reports have a plethora of issues that we have to categorize and deal with. We have to deal with issues of the stubs that are found in a particular ballot box, not corresponding with the number of ballots. That's a reality. We have to deal with issues where significant numbers of ballots found themselves unstamped with a 6-digit stamp. Now, in a sense, we took a position on the matter, but you have situations where in a box, half of the ballots representing probably the general election are stamped, and the other half are not stamped. And people go for this hard and fast rule that if it doesn't have a stamp, it's not valid. I would have thought that the reason why we place stamps on ballots is to determine the authenticity of the ballot. That's the reason. And so when one has to make a decision on matters of these, you don't just simply say the law says. You have to say why the law said, and to use the basis of why the law said as the basis of making the determination. If the law's intent was to ensure the ballot is authentic, and you go into a box, and half of the ballots, half of the original ballot paper is stamped, and the other half are not stamped, what logical conclusion can you come to but that the other half is also an original document and therefore has the validity which you're looking for? Now that kind of logic is not being applied, and therefore people in that regard could be disenfranchised, and people simply don't care about that, though they speak aloud about democracy and transparency. And so there are fundamental issues that have to be determined in the course of the consideration of the observation reports. And we cannot allow those who think that we merely do the numerical account to get away with that account when there are so many other issues that impact the quality of the elections that have to be considered.
Mr. Alexander, to what extent is the 13th of June date set?
The Secretariat has given us an undertaking that from the pace at which we're working, this exercise should be finished by the 13th.
But that is not a decision?
Well, insofar as we have not completed the work of the order and have not yet gazetted the order, it could change. But there was really no dispute in that regard. But it's not yet gazetted.
Do you see any implications to the recount going beyond the date currently set out in the order, the timeline?
In the order, there wasn't a specified date. In the order, we had said 25 days,
Right.
subject to review. It is obvious to all of us that we will go beyond the 25 days. That is obvious. And therefore, we are consciously considering what date we will now put. And as I said, in principle, we've agreed that the 13th of June is that date.
JPOM is considering collecting evidence from the
I wouldn't use the word collecting evidence. If the coalition has issues, they have to present the evidence. GCOM would, in fact, be the recipient. But we're not going about collecting evidence from the coalition.
Okay, there's an argument that going about this route would be contravening Article 163, that GCOM would be infringing on the exclusive jurisdiction of the court. Has the Commission considered that argument?
The Commission considered all of those arguments when they took a decision to use 162 and Section 22 of the Elections Amendment Act. Now, there may be different views on this matter. If there are different views in this matter, then there's only one place for those views to be determined.
I understand what the order is grounded in, Article 162 and Section 22. But the PPP is arguing that Article 163 of the Constitution does not allow GCOM to go beyond this numerical count and to try to determine whether the elections were fraudulent in any way. The court has to do that.
Which article of the Constitution allowed for this recount? The Representation of the People Act did not allow for this recount we are doing. It is a set constitution by virtue of Article 162. So that the determination of these matters in a common law system are only final if a court decides. The view that we have held, by virtue of what's in that order, an order which was agreed to by the Commission, is that we are not doing a mere numerical recount, that we are in fact going to have observations beyond the numbers. And we are having observations beyond the numbers.
So the Representation of the People Act does not allow for the recount, but Article 162 allows GCOM to take any action as it sees fit.
That was the interpretation of 162 by all the sundry.
So the argument now is that Article 163 specifically prohibits.
That is not the considered opinion of GCOM.
Okay.
GCOM is operating under this considered opinion, and those who may have a different opinion have an equal right to have that opinion determined in the right place.
Okay. Can you say how many ballots are unstamped? Is there a number?
Oh, there are many boxes. I don't have a total, but there are many boxes. I got, for example, in one instance today, a report in box 4101, one was unstamped, box 4104, 21 were unstamped, box 41, 75, 13 were unstamped, box 43, 14, 10 were unstamped. Oh, there are many.
So is that in the vicinity of hundreds, thousands?
Huh?
The vicinity of hundreds or thousands or just tens?
I have just given you what I got from today.
From today. Okay.
And this is not all of today.
You were saying that a position was taken on the unstamped ballots. Can you elaborate on
A position was taken which said that if a ballot is unstamped, then that's it, not to count it. But I think that this is a matter that obviously with the magnitude and the number of ballots unstamped and the circumstances of them being unstamped has to be reviewed.
Just to follow up, I know some time ago you mentioned the joint services ballots may have been affected, and there was a mechanism in place to maybe, if they matched the number that was supposed to be intermixed with those unstamped ballots. Could you say if the joint services for sure ballots may have been affected?
Let me answer you this way. It was my proposition that one could be certain about the accusation if the number of unstamped ballots corresponded with the number of intermixed ballots. So we pursued that course of determination, and as far as I know, we have not come up with any instance where the number of unstamped ballots correspond with the number of intermixed ballots. However, there is still the contention of some, that the incidence of on-stamp ballots seem to coincide for some reason or the other with boxes where there was an intermix. But that's a difficult situation to handle.
Could you say what information the Commission has in relation to the allegations that are being made by the coalition? They spoke about giving the Commission some amount of information that included death certificates and information about people who may have migrated. And also, sir, could you tell us about, are there more than 100 missing poll books? We've been seeing some numbers being thrown around.
I don't have a number, but I would easily come to the conclusion that yes, they may be in that vicinity and greater.
How did this happen?
The Lord knows. We have to find out.
Are the presiding officers not explaining why the poll books are not being accounted for?
At this time, I don't think that except for two presiding officers who were called in relation to the Diamond Nursery School, where for some mysterious reason, the OLE for one station was found in the box for another station, and vice versa, the OLE for that station was found in the box of the other station. So those two were called in. I don't know if we've called in others at this point in time.
Did they provide an explanation to the so-called mix-up?
I heard of an explanation where one of them said that he discerned this problem at the commencement of the exercise, and in order to facilitate voting, was sending people to the other station to verify their name to come back to vote. Quite a funny story, but that's an explanation that I heard third hand. I haven't heard any first-hand explanations.
And my first question about this so-called information that the coalition may have given the Commission.
But I know so far they have provided us with names of persons who, according to them, would have migrated, would have been absent from the country, and who would have been voted for. Those huh?
Names?
Yes, they provided us with names.
Just to follow up, sir.
I'm not finished. Those have been sent to the Chief Immigration Officer for verification. Like I said on the previous occasion, the Chief Immigration Officer, under Regulation 40 of the National Registration Act, has an obligation to periodically provide that information to the Chief Elections Officer, the Chief Registration Officer. So I think it's in that context the Chief Registration Officer has requested information from the Chief Immigration Officer.
Mr. Alexander, you spoke earlier to the observation report by the Chief Elections Officer. At what point the Commission will consider the report from the curriculum scrutinizing chief, and how will this impact on the final announcement?
Two things. The order does provide for them to submit a report, and in the order it specifies somewhere around paragraph 13, I think, that they submit that report. In the normal course of things, that report lends to the credibility of the exercise, but in itself will not be a determining factor about the exercise. I think a number of days, 3, 4, 5 days at most. At most.
Mr. Alexander, about the methodology that you had put forward to determine whether certain on-stamp ballots are additional services, is that really a certain foolproof methodology? I mean, if you get 3 on-stamp ballots for 1 ballot box.
No, we are saying if the absolute number, you are intermixing 36 per box. If you found 36 on stamp ballots in a box where we intermix 36, then that is how one would come to the conclusion that this appears to be a problem with the discipline services votes. But we have not found that.
That could only be
But suffice to say that in making these determinations, there have to be principles that are applied. And one could borrow principles from the law. Now, in the law, if you go to court for a criminal matter, they have to prove beyond the shadow of doubt. Right? That's the principle applied in a criminal matter, beyond the shadow of doubt. In civil matters, it is the level of probability. It means if you think that the probability is 50% plus, then that's it. And so I would apply, in a circumstance like that, the level of probability. We haven't had reason to apply that principle.
I did not get a better word. I used the word collection of evidence. So you don't prefer that word, but I'll use that word for lack of a better word. When will GCOM consider the evidence? Will it be supplied with observation reports after the recount?
My understanding is that when we come to consider the reports of the various districts, then there should be a holistic consideration. That is a consideration of the tabulation and at the same time the observation reports.
But the evidence that has to be
We will not consider something that has no material evidence.
but they said they're going to give evidence to GCOM.
Right. So they have to give it to us.
So if or when they give it to you, what will that be supplied with? Will it come at the end of the recount when the commission is considering the observation report?
At that time.
Okay.
At that time.
Thank you.
Sir, sorry. I wanted to find out, you said that the coalition sent names to the secretariat. Could you say how many names?
I don't remember the number. I saw a few sheets.
You saw a few?
Yeah, more than one.
So the secretariat has initiated the process of accessing this
It's the
information.
chairperson who's done that, not the secretariat.
Okay. The chairperson will
Yes.
request it.
Yes.
On the matter of the foreign voters, those claims, the coalition has indicated through Mr. Norton yesterday that it expects GCOM to use its legal privileges to access the records.
I've referenced that already. That is the information which has been sent to the chief immigration officer.